Good evening, everybody, and welcome. My name is Sam Seymour, and I'm president of the New York City Bar, and it's a great privilege to welcome all of you here tonight. We have a wonderful evening of celebration ahead of us. We're here, of course, to recognize Judge Jack Weinstein, who has been a giant of the federal bench, and his record of accomplishments is truly unmatched, and he really defines what it means to be a judge. And we're delighted tonight to honor Judge Weinstein on the occasion of his first 90 years and his first 45 years on the bench. And we're going to hear tonight from this distinguished panel who will reflect on the judge's prodigious work, his approach to judging and case management, and his impact in many aspects of jurisprudence. The particular date of this program was inspired not only by Judge Weinstein's recent 90th birthday, but also by the publication of a book on his judicial work by Professor Jeffrey Morris, who is one of our panel members tonight. That book is entitled Leadership on the Federal Bench, The Craft and Activism of Jack Weinstein. You can enjoy reading about the judge's career, which has been distilled down to a crisp 400 pages, which is about the length of some of Judge Weinstein's great opinions and MDL actions. But tonight the panel will put a particular spotlight on his career from the panelists' different perspectives. I myself can speak from my own personal perspective, having tried a case a few years ago before Judge Weinstein. I was pro bono counsel appointed to represent a criminal defendant in a brief jury trial that Judge Weinstein presided over. Unfortunately, justice was done, and my client got the unfortunate one-word verdict instead of the two-word verdict he was looking for. But it was a wonderful experience to appear before Judge Weinstein, however briefly. It was a few-day trial. At one point there was a dispute over an evidentiary ruling around hearsay, and I must tell you, if you haven't experienced it yourselves, debating with Judge Weinstein about hearsay is really a very daunting thing. I don't look forward to that. As many of you know, he also has some wonderful sort of unorthodox practices in the courtroom, at least from my experience. And one of the wonderful things he did after the trial was over, and unfortunately it was a guilty verdict in a criminal case, we asked if we could speak to the jury. And most judges discourage that. U.S. attorneys always discourage that. But as a defense lawyer, I thought that was a wonderful idea. And the judge said it was fine with him, and he didn't even preside. He just said, they're in the room. If you want to go talk to them, go ahead and talk to them. So all the lawyers went in, and we had a wonderful chat with the jurors who said that we, the defense team, had done a very good job, but just not quite good enough. But it was one of my favorite moments when one of the jurors asked for my card because he said his son had a problem. So it's not usually the case that you get referrals from the jury, but that has happened. You know, here at the City Bar, we're particularly happy to be hosting this program because the New York City Bar Association is approaching the 59th anniversary of Jack Weinstein's membership in the New York City Bar. And I note from Jeff's book that one of Judge Weinstein's early activities as a member of this association was using our library up on the 4th floor while working with Thurgood Marshall on Brown versus Board of Education. And I'm very proud of that particular connection to that case and to Judge Weinstein. More recently, in 2007, Judge Weinstein was our Benjamin Cardozo lecturer. And of course, in addition to a wonderful speech, Judge Weinstein produced a treatise-length version of the lecture, which was published in our 2008 edition of the Record. In fact, I think it was the 2008 edition of the Record, and it's available online. And that, of course, is just one of so many wonderful contributions to academic writing that we can thank Judge Weinstein for. So I'm delighted to turn the podium over to our panel, beginning with Professor Jeff Morris, who, in addition to being a celebrated author and wonderful legal historian, is a professor of law at Touro Law School. So join me in welcoming Jeff Morris, please. Thank you. Thanks very much.
Sometime in my last year in law school, I realized first that I was interested in courts and judges as legal and political institutions. And second, that no scholar, whether of the law, political science, or history, seemed to be interested in writing about any courts or any judges unless they were members or former members of the Supreme Court of the United States. Somehow I stumbled into a career largely writing about courts and judges other than the Supreme Court, and I've been fortunate enough to gain access to and learn from men and women of the caliber of David Bazelon, Marvin Frankel, Ruth Bader Ginsburg, Wilfred Feinberg, and Patricia Wald. But no experience I've had as a scholar has been remotely like those conversations I've engaged in with Judge Weinstein. For almost 20 years, we have sat in his home overlooking the Long Island Sound, sometimes a bit distracted by the antics of waterfowl, and in season our view includes abundant floral life. In these conversations, which have run 2 to 3 hours, and which were originally not intended to produce a book, in these conversations the judge discussed a very large majority of the cases in which he had delivered written opinions and some in which he did not. We both prepared for these discussions. My role was exceptionally minor, perhaps a bit like the manner in which the judge characterizes his role when working on the brief in Brown versus Board of Education as just, quote, just a general purpose associate floor sweeper. For each case, many of which had occurred many years before, Judge Weinstein reflected on how the case developed, the lawyering of the parties, the trial, what he did, and why he had done what he did. The seemingly inevitable reversals on appeal were also discussed. In this 2,000-page oral history, Judge Weinstein has done what very, very few judges have ever done, and no judge, I believe, has done at such length, which has been to reflect upon the decisional process and consider in each case not only the weight of legal factors, but also what it was in his background that affected the way in which he perceived the case or influenced him to do what he did. I believe the oral history, which will be open to anyone, is probably the lengthiest and surely among the deepest set of reflections by a judge on the nature of the judicial process. The oral history will be, I believe, of enormous value to future students of the judicial process. Let me just say briefly that my book is a study of Judge Weinstein's judging. It is not a 2,000-page manuscript of oral history. Let me speak of the man. Strong and resilient, he is enormously passionate and sentimental. His loves punctuate his reflections. The large, warm family in which he was brought up, his love of the borough of Brooklyn, of the men he worked with on the docks as a teenager, of Columbia, of his wife Evelyn, to whom he has been married for over 65 years. And what of the other passions of the man? His deep belief in equality, his love of country, his great pride in the American legal system. And Weinstein is passionate about the proper role of the federal court system to protect the injured who come before federal judges against those who have caused or are not, of those who have caused or are causing unjustifiable harm. There is also his penchant for innovation, of which I suspect Professors Mullenix and Cote will have something to say. And to be sure, Judge Weinstein's unwillingness to be cabined within the limited role most judges impose on themselves or the appellate courts insist upon. Perhaps his greatest passion as a judge has been his profound belief that the law have a human face, something joined with his deep well of compassion. I'm sure Professor Stith will have something to say about this when she speaks about the judge and sentencing. But his concern for and his treatment of people can be seen as well in his class actions and other civil cases. He has wept for the DES mothers and DES children. He has wept for the afflicted veterans of Agent Orange, the disabled children and their parents in the Suffolk County developmentally disabled case, the battered women whose children were taken from them by a New York City agency because they had been battered by a husband or a boyfriend. How can one begin to do justice to the range or depth of Judge Weinstein's career? That includes, of course, his role in the creation of the CPLR and the Federal Rules of Evidence, his treatises, his casebooks, his well over 200 law review articles. I started to count them today, and I gave up at around 205. Hundreds of speeches, a teaching career lasting 60 years. There is his election campaign for Chief Judge of the New York Court of Appeals, his tenure as Chief Judge of the Eastern District, his role in creating Nassau-Suffolk Legal Services. There are the opinions we don't have time to cover tonight. The large litigations involving the New York City schools, especially the Coney Island case where schools were desegregated successfully, a rare phenomenon. The settlement of the Shoreham nuclear power plant case, which was poisoning the politics of Long Island. There is a fascinating array of First Amendment cases, Title VII, Section 98, 1983 cases. And there are his treatment of petitions for habeas corpus. And in addition to those that have been assigned to him regularly over the years, at the age of 82, the judge volunteered to take the backlog of habeas petitions from all of his colleagues in the Eastern District without a reduction of his own caseload. And Weinstein resolved the 500 petitions he was assigned within 9 months. One of the virtues of spending time with Judge Weinstein is exposure to his sense of humor. And I can't conclude without offering a few examples of Weinstein's wit. There was Weinstein responding to a reporter's question about the credentials of Stephen Breyer and John Newman, both then under consideration for appointment to the Supreme Court. Weinstein replied, "I'd be proud to be reversed by either one of them." In 1978, when an attorney for a defendant whom Weinstein had just sentenced to 3 years in prison for embezzlement argued, "The President of the United States got an absolute pardon. To put this man in jail makes a mockery of justice," replied Weinstein, "But Mr. Nixon was not before me." One day, I was asking Judge Weinstein about settlement and how he goes about trying to achieve it. And he put it this way: "Whenever I have a case that is difficult, I say to the lawyers, 'Have you considered the choice of law problems in this case?' Go out into the hallway and discuss them." And I'm not sure this is an example of an amusing anecdote. It's pure Weinsteiniana. Of one defendant, he said, "I rather liked this guy. Though he was a crook and a drug dealer, he was otherwise a charming fellow." The judge has always been a moral force on the bench. And I'd like to close with just one paragraph from one of his speeches. Sometimes, he said, we reach out to another human being and there flashes between the two a spark of responsibility for each other and wonder at the spark that constitutes what some believe is the essence of a soul. At such times, the cold, just, uneasy universe no longer threatens and overwhelms with its almost timeless sense of justice and the individual's irrelevance. We rise above our limitations when we feel responsibility for one another, ignoring for the moment our mortality. We succumb to our humanity and embrace mercy. Thank you. Oh, I'm sorry, I'm also supposed to play the role of moderator. I have the honor to introduce Judge Denise Cote, who is not only a member of the bench of the Southern District of New York, but a former Weinstein clerk.
I would like to thank the City Bar for giving me this opportunity to give you an insider's view of Judge Weinstein's life as a judge. My recollections of my clerkship with Judge Weinstein over 35 years ago remain vivid. I've structured my thoughts around 4 traits of Judge Weinstein's that stand out in my memory: his energy, his efficiency, his intellectual engagement, and his empathy. Now that I'm a federal judge as well, these traits loom even larger in my thoughts. Judge Weinstein's energy, as Jeff has already mentioned to you, is truly legendary. Being a district judge is job enough for most of us. But for Jack Weinstein, it was simply one of the many things he did. During most of his career on the bench, and this pattern was already well established when I was with him, he taught in law school, he gave innumerable speeches, he worked on his treatise on evidence, he wrote books and articles beyond number. As you may know, his treatise on evidence, which he authored with Margaret Berger, is the leading treatise on the law of evidence. He was a member of the advisory committee that drafted the new rules of evidence for Chief Justice Warren in 1965. So his impact on the law of evidence comes from at least 3 separate directions. He was one of its principal drafters, he was the author of the treatise on evidence, and he wrote frequently about evidentiary issues that arose in his courtroom. And I assure you, he had many opportunities to examine the rules of evidence as they were being applied or ignored. His courtroom was a whirlwind of activity as the judge juggled a myriad of matters. So much was happening at once. At one point during my clerkship, 3 jury trials were going on at the same time. I cannot explain to you how that happened, but I assure you that it did. One jury was deliberating, another trial was finishing, and a 3rd jury was being selected. Being a law clerk in a courtroom with the judge during a trial had its very grave risks, though. Once the judge signaled for me to come up to the bench during an attorney's contentious examination of a witness. And Judge Weinstein said to me, "I can think of 3 ways in which this testimony is admissible. How many can you think of?" The judge's energy and efficiency went hand in hand. Without his practical, no-nonsense approach to every task, he could not have kept so many balls in the air and accomplished so much. Of course, part of his secret was just plain hard work. He is incredibly disciplined, and he used terrific judgment in deciding how much effort each task should take. The judge's approach to deciding many motions is a good example. It was the most efficient method imaginable. The law clerk would prepare a short memo stating the issue, the legal standard, and a proposed analysis. Then I would collect the federal reporters with the cases cited in the memo, put them on a wooden cart with the parties' briefs and the memo, and wheel everything into the judge's room. He worked late at night and arrived at the crack of dawn and was often prepared to rule from the bench. Not infrequently, however, I had failed to grasp the essence of the issue, and he had to figure the right way to deal with it without much help from me. In other words, from a law clerk's perspective, the judge did all the hard work. I'll trust that others will talk about how his efficiency has infused his management of mass tort litigation and other procedurally complex areas of litigation. But I observed efficiency in how he organized his life in chambers and the management of his docket so that he could accomplish more in a single day than most of us would accomplish in a week or a month. And he applied this same practical approach when he became chief judge in the Eastern District, where he served for 8 years in that capacity. These first two traits of energy and efficiency can't be mentioned, though, without talking about the judge's abiding intellectual engagement with every issue that comes before him. The judge's dedication and efficiency weren't important in their own right. They were means to an end. They permitted him to accomplish so much that was worth doing. This intellectual engagement is a fundamental part of his nature. Most of us, when confronted with a problem, want to learn enough to arrive at a satisfactory answer. I don't believe that is how Judge Weinstein thinks. To Judge Weinstein, a motion in a case or a defendant awaiting sentence are occasions for reflection, for learning, for conversation, for engagement. For example, his efficient approach to handling motions, which I believe he derived from the British model, had its exceptions. There were issues on which he decided he would write at length because more just had to be said and had to be said in a public forum. And I imagine each of you has had the opportunity to read at least one of those landmark opinions by Judge Weinstein. The background and analysis section in those opinions describing how we got to the state of affairs that was at issue in the case are invariably exhaustive and illuminating at the same time. Judge Weinstein's wisdom can be found in FSUP in almost every field of law that comes before a federal judge. During my clerkship year, I was able to assist the judge on one such project. It was an environmental dispute. The judge stopped oil drilling off the coast of New Jersey. And aren't we all glad that happened? Thus, the entire justice system has been improved because Judge Weinstein has applied his talents to thinking deeply about so many issues, including structural issues like access to justice and transparency. For him, these were issues of importance not just in the single case in which they arose on his docket, but for the court system and society as a whole. The last trait I've chosen to discuss is the judge's empathy. Judge Weinstein doesn't breathe without thinking about others. Every colleague, friend, former law clerk has received a bushel basket full of handwritten notes from him. It is his empathy that informs and motivates, I believe, everything that he does. That is why he works with such energy. That is why he cares about being efficient and why he has such fierce intellectual passion. As a law clerk, I saw Judge Weinstein sit at a table in the well of the courtroom with the defendant he was sentencing seated directly across from him. He didn't wear his robes. Judge Weinstein knew and felt the weight of the sentencing decision and did not shirk from exposing himself to the raw emotion of that moment and to the defendant, those who love the defendant, and in some cases the victims of the crime. I believe that he wanted everyone to feel that on this, one of the most important days in a defendant's life, that person had been seen and heard. What was clear to everyone in the courtroom was that the judge had thought so carefully about the individual and what the right sentence was for the person. And he didn't put on rose-colored glasses in doing so. He brought all of his knowledge of life to bear on understanding the person in an unvarnished light. If in his mind the right sentence was a long one, then he would impose it. After all, he had worked on the docks. He had been an officer in a World War II sub. He had seen and done hard things. But if he believed that the right sentence was far shorter than the expected one, then that was the one he would choose to impose. And as we know, he's been tough enough to take the criticism that came with that decision as well. In closing, it was one of the blessings of my life to clerk for Judge Weinstein. He is a force of nature. No one has a bigger heart. His energy is boundless. His intellectual engagement with every issue he confronts, large or small, is exceptional. He is an American hero and a judge without equal.
Professor John Coffey of Columbia Law School.
Thank you. There is almost certainly no district judge in U.S. history or in the foreseeable future who has been the subject of as many law review articles about him and his style of judging. Now, that style of judging is going to be the focus of my brief comments. Listen to the titles of all of these articles. Here's one by David Luban back in 1997, and its title is Heroic Judging in an Unheroic Era. Now, I would love to steal that title because it applies even more today in an even more unheroic era, but it was all about Judge Weinstein's style. This literature began back in 1982 with an article by Judith Resnick of the Yale Law School, which characterized Judge Weinstein as a managerial judge. This led to an awful lot of debate, backwards and forwards, about what a managerial judge was. I would note for the record, it's probably not good to be an unmanagerial judge or an anti-managerial judge, but it seemed to mean a judge who consciously sought a dispute-resolving global settlement from early in the actions litigation. And that debate has gone on through many articles. Martha Minow, once a professor at the Harvard Law School, but recently demoted to an administrative status there, she has written, she captioned her 1997 article about Judge Weinstein with this obvious reference to Louis Brandeis. She called it Counsel for the Situation, Jack Weinstein, Creator of Temporary Administrative Agencies. Her point was that in his really complicated major settlements, he created a full staff of masters and magistrates all working together to craft a massive settlement. Now, as she recognized, while it was problematic for an attorney to be counsel to the situation, it was sometimes necessary for a judge to be counsel to the entire situation in order to get anything that was meaningful reform. All right, now, the consensus view of this special genre of law reviews, and I'll call this special genre Weinsteiniana, and it would fill 2 or 3 shelves of any law review library if you put them all together. The consensus view of all these articles is that Jack Weinstein is the paradigm of the public law judge. Unlike the private law judge, the other polar figure, the private law judge is a neutral umpire resolving a bilateral private dispute. The public law judge instead faces a multi-centered social problem, perhaps a dysfunctional and even barbaric prison system, perhaps a de facto segregated school system, or perhaps a gerrymandered state legislature. Okay? These are not bilateral private disputes, and the judge is called upon as a public law judge to arbitrate, to mediate, to negotiate, and to try to reach a solution by dealing with all of the many players who play critical and roles that have to be dealt with in order to get to a settlement. Probably the iconic example of this activist approach is the judge's handling of the Mark Twain school case in 1974, where the judge involved not only the parents and teachers, but the teachers' union, community leaders, the churches, housing officials at city, state, and federal levels, the MTA, the Parks Department, and the New York Police Department. The judge appointed another colleague of mine, the late Kurt Berger, to be a special master and develop a comprehensive community development program. Now the judge, showing caution and I think prudence, never adopted or imposed that community development plan, but it became sort of a model of what might be done. Many people have studied this process, and I think they have generally reached an agreement that while maybe not everything was done to fully and adequately resolve the problem of education and equal opportunity in New York, there were major steps forward, and this did ameliorate the problem, and it did get people integrated and thinking about a comprehensive solution. Okay, now, other judges, and here's my key theme, other judges have used this expansive public law approach with regard to many other public institutions. None has done it quite as actively as Judge Weinstein, but the unique and very special distinctive contribution of Judge Weinstein has been to take this public law approach and apply it to the special context of mass tort litigation. Now here, the Agent Orange case in 1979 shows the hallmarks of his style and his insistence on being counsel to the whole situation. Essentially, he inherited some 600 cases involving injuries to Vietnam veterans and their families caused by a defoliant chemical called Agent Orange. These cases had all been consolidated, and the judge then sought relentlessly to not allow any party to escape this litigation. He might not accept this, but I would say he relentlessly kept all the parties in the litigation. No one escaped, particularly not the United States as the defendant, because it was only with all of them in it that he thought he could craft a global settlement. Eventually is a long time, but eventually a broad monetary settlement was achieved, covering both present claimants and even unborn future claimants. Now that's counsel to the whole situation. And a class action settlement was ultimately approved by the Second Circuit, although the Second Circuit certainly did cut it back a little at the margins and have some reservations here and there, but it went through. Okay. Now many have criticized Judge Weinstein's efforts to treat mass torts as a public law problem. But I want to point out in a limited way that the one thing about mass torts is they are inherently not bilateral. They are inherently multi-centric. That's because the plaintiff class in a typical mass tort action is deeply internally conflicted, with the sharpest conflicts being between present and future claimants. Alas, sadly, future claimants are often underrepresented, sometimes notoriously so, and sometimes the present claimants and the defendants can reach a settlement that maximizes their interests but sells out the future claimants, leaving the future claimants out in the cold when their claims mature many years later. It is possible that that ultimately did happen in Agent Orange, or at least the Second Circuit in a later case felt that the future claimants had not been adequately protected after the time of the settlement. So we still have problems with mass torts, and time and tide have changed, and the courts are no longer approving that kind of settlement. But I'll point out one other thing showing the judge's style. When the judge has seen a mass tort settlement jeopardized by the threat of insolvency, he has not remained passive on the sidelines, but has characteristically waded into the Serbonian bog of bankruptcy reorganizations to salvage the settlement by very active management. This is referring to the Johns Manville asbestos cases, and we don't have time to go into all that, but he did not sit on the sidelines there, and no obstacle, including the maze of bankruptcy law, kept him from pursuing what he thought needed to be done. Now, because many others have used this public law metaphor to describe Judge Weinstein's style of judging, I want to abandon this term, it gets a little bit overused, and unpack this idea of his style into its constituent elements. I only have time to discuss two of those elements, but I want to discuss these two. To my mind, what really characterizes Judge Weinstein's style of judging are the following two elements. The first is an inclusive style that maximizes empathy for the individual. Most judges deal with lawyers in the courtroom and do not attempt to communicate beyond the courtroom. Not Judge Weinstein. In Agent Orange, he held a nationwide series of, in effect, town hall meetings across the country to reach the affected class members and to reach them as individuals. Other judges probably shrink from this, believing that it might appear to compromise their objectivity. But not only did Judge Weinstein communicate, but he proved himself an extraordinarily effective listener, a very empathetic listener. All of this, I believe, maximized the therapeutic value of this settlement. Not usually a concern of judges, but I think it made Agent Orange a very different kind of settlement that led to a more satisfied class than those who simply get a check in the mail. Okay, now the other unique style element in the Judge Weinstein judging process is a quiet but determined recognition that there are moral imperatives in judging, that the judge himself cannot be used even directly and minimally, even indirectly and minimally, to assist the state to achieve an unjust end. Whether we are talking about mass torts, drug cases, or sentencing, which Kate Stith will turn to in a moment, the judge has been led in all of these areas by a conscience that is at least as guided by moral as legal values. He will not let the judiciary be used as a tool of the state to achieve an end that he thinks is unjust. You know, Judge Weinstein does not go back to the fugitive slave laws, but if slaves were brought before him in 1840 for rendition, I know the way he would rule, and I know the way some of our legal positives would rule, and they would go in different directions. Okay. In closing, I have sometimes told my colleagues at Columbia, or half jokingly, but we've agreed on this, that Judge Weinstein is probably the only Old Testament prophet that we personally know. Now, that's overstated, but there is some truth in this. Ultimately, and here I close, ultimately our lives are most enriched, most ennobled by encountering men and women who live on a higher plane of moral intensity than we can personally occupy. I am proud and enriched to know Judge Weinstein. I hope you have been too. Thank you.
Professor Linda Mullenix of the University of Texas School of Law.
Good evening. I would really like to thank the Bar of the City of New York for bringing me up here from Texas. I actually am a native New Yorker. I grew up here. I went through public schools as well as the college and university here. And it's a great relief for me to be back in a place, in a venue where nobody thinks I have a funny accent. I'm here in the role of what I characterize, and the people on the panel know, as admiring critic of Judge Weinstein. And I teach mass tort litigation. It's my primary field. And I actually have the only casebook in mass tort litigation out there. It's 1,400 pages in large measure because of the problem of dealing with Judge Weinstein. casebooks today are considerably shorter than when we were in law school. Another characteristic of modern casebooks is the case excerpts now are considerably edited down to 3-4 pages. And so every time Judge Weinstein issues an opinion, he has been the bane of my existence. How do you shrink a 120-page decision down into something you can put in a casebook? So I always warn my students that they're going to have a lot of reading to do, because I do extensive case excerpts from his decisions. So in addition to being the bane of my existence, he also is the boon of my existence, because teaching his decisions has been incredible fun. And I think the theme that I want to present to you is, as we all know, Judge Weinstein, particularly in the area of his decisions in mass tort, he has been reversed a considerable amount of time. On the other hand, which makes it fun to teach. On the other hand, in so doing this, he really has pushed the law, and he's pushed the conversation considerably. And so this is almost an interesting example of failing up. And so what I want to do is talk to you about some of his very interesting decisions where I think he's actually pushed the law or gotten us to think, or started an interesting conversation. The place to begin, always in talking about mass tort with Judge Weinstein, is his handling of the Agent Orange litigation. And what's the legacy of that? It's a very interesting legacy, because in spite of the fact that even Judge Weinstein believed that there were going to be causation problems with the plaintiffs in that class being actually able to prove up those claims, he did broker the settlement and approve the settlement, which was affirmed by the Second Circuit. And then for all the opt-outs, ordered summary judgment against those claims. What's the legacy of that? Well, it was the beginning of the fund approach to resolving mass torts. It was almost the paradigm or the archetype of that. And it also gave us Ken Feinberg, because Ken Feinberg was the special master who worked with Judge Weinstein on the Agent Orange litigation. And as we all know, Ken Feinberg then went on to be the special master in the Victims' Compensation Fund, and he's now doing the Gulf Coast Claims Facility. And there's another strange legacy of the Agent Orange litigation, which is almost 20 years later, veterans who were suffering cancers 20 years down the road tried to claim against the fund, and that led to basically a collateral attack, a case known as Stevenson versus Dow Chemical. And Judge Weinstein, who is still supervising the Agent Orange litigation, basically said, res judicata. You know, the settlement has been approved, you didn't opt out, and you can't take from the fund. That went up to the Second Circuit, and on due process grounds was reversed. But what this did was basically, I think, focus the attention of attorneys who work in the settlement area, particularly in mass torts, to focus on the problem of adequacy of representation at the time of settlement. So it's a very, very interesting legacy of the Agent Orange litigation. I now want to discuss with you 4 other examples of very, very interesting decisions by Judge Jack Weinstein. And in talking about these decisions, I want to plant in your mind the thought that I would characterize these as interesting examples of Judge Weinstein's version of magical realism. I think he's redefined this concept, because I think what he's done here is kind of interestingly pure magic, and I discuss this with my students. There was a tobacco, Judge Weinstein was presiding over third-party tobacco litigation, a settlement in litigation known as In Re Simon II. And what he seized upon in attempting to settle this out was to certify what we call a limited issues, punitive damage class. And not a limited issues not a limited issues class, but a punitive damage class only. And the construct that that was the linchpin for doing this was his recognition that the series of punitive damage decisions from the Supreme Court had set some kind of constitutional limit on the amount of punitive damages that might be recovered. And his concept was, in setting a constitutional limit on the amount of possibly recoverable punitive damages, that created a limited fund. And that was the basis on which he certified the punitive damage class in Simon 2. When I read that, I thought it was conceptually quite interesting. The Second Circuit didn't think it was quite interesting. They reversed it, but I don't think that, I think that that's an argument which will continue to be pursued. I don't think that we've heard the last word on the possibility of the punitive damage class based on this theory. In another mass tort case, Judge Weinstein was confronted with a situation where he had a settlement before him, but there was a pending parallel settlement in state court. And the existence of the pending parallel settlement in state court was going to jeopardize the settlement that was in federal court. And so what he wanted to do was basically exercise the injunctive power of the federal court to shut down that parallel state settlement. The problem with that was that there was existing precedent in the federal system which very clearly said that the Anti-Injunction Act prohibited a federal judge from enjoining a pending parallel proceeding. And what Judge Weinstein did, and again I thought this was absolutely magical, he invoked an exception to the Anti-Injunction Act which says if you have pending proceedings in federal and state court that are both in rem, that is an exception to the Anti-Injunction Act. And how did he define his settlement as being in rem? He said the settlement is the res. And because the settlement was a res, he had an in rem action in federal court and he couldn't join the state action. Very inventive. In the DES litigation, he had before him a question of personal jurisdiction and whether or not he could exercise personal jurisdiction over non-resident defendants. And so, of course, I read this decision. It was huge. It was one of these 120-page decisions. And he started off in the decision with a description of the underlying facts of the DES litigation, the procedural history, and then he turned to the law portion of the case, and my heart sank because he began with Panoia versus Neff. And I knew it was all over because from Panoia versus Neff, he marched lockstep through Hess versus Pulaski, International Shoe, Schaefer versus Heitner, Worldwide Volkswagen. We're 40 pages in there. And he's going on and on through every single case in the personal jurisdiction line of cases. And he gets to the end of this, and he says, as we can see, mass torts are different, and therefore they require a new theory of personal jurisdiction. And this case is in my casebook. The whole thing is in there. It's amazing. All right, anyway. The last example I want to give you is a very recent example, and it is in the Zyprexa litigation. Again, this is what I call kind of magical realism. Judge Weinstein kind of invoked his equitable powers as a judge to resolve all the Zyprexa cases under the doctrine of what he calls a quasi-class action. And when I read that, I just about had it. I thought quasi-class action, it's like being a little pregnant. Okay, what is you have a class action or you don't have a class action. What is a quasi-class action? Anyway, he is the creator of the quasi-class action. I want to close by saying I think the other area in the law where he has really pushed us and pushed the conversation in the area of mass torts is to have us talk about professional ethics in mass tort. And a long time ago, okay, at the outset of this era, he's written many books about mass tort, but he also wrote a landmark article basically called The Professional Ethics in Mass Tort Litigation. It's published in the Northwestern Law Review. Again, it's over 100 pages long, but he was one of the first people to recognize that mass tort litigation raised professional responsibility issues that just were not dealt with in our codes of professional responsibility. And he urged the bar, he also urged the American Law Institute to basically think about the special problems of professional ethics in mass tort, and to think about beginning to promulgate some types of rules of professional ethics to govern these cases. Finally, I want to close by saying, and I had this conversation earlier in the evening with Professor Morris, and I told him I always have this struggle in my own soul about Judge Weinstein, because his judging comes from a wellspring of compassion and empathy, and that's one side of my brain. And I told Professor Morris the other side of my brain that I struggle with is the rule of law. And I've never been able to reconcile these two halves. But what I recognize about Judge Weinstein is that he has completely integrated both his compassion and his empathy and the rule of law together in his persona, and he is a much, much better person than I can ever aspire to be.
Has Judge Weinstein, over the course of decades, fundamentally changed the contours of law and practice in this area? I think he would say, not enough. But that's not for lack of trying. In addition to all the law review articles and speeches, he has written scores of sentencing opinions that exceed the standards of the most exacting academic, thorough, analytically impregnable, and heavily footnoted, attempting to get the Second Circuit, the Supreme Court, and the Congress to remake sentencing law. He has not waged these battles alone, but more than any judge I can think of, he's waged them continually on every front, with powerful intelligence and humanity. In these ways, he is one of the creators of today's new sentencing landscape, in which judges are allowed to consider not just what the Sentencing Commission proclaims, but what justice requires. Never content to rest on his laurels, Judge Weinstein has, in the years since Booker and its progeny, turned his sights primarily on the guidelines' tough cousin, mandatory minimums. And looking to stir up a little controversy for a change, he's taken on sentencing in child pornography cases. The first case to recall this evening actually involves neither the guidelines nor mandatory minimums. In 1977, Judge Weinstein had the duty to sentence Daniel Fatico, who had pled guilty to one count of conspiracy to receive stolen goods in interstate commerce in connection with a truck hijacking at Kennedy Airport. The government advised the court that at the sentencing proceeding, it wished to call an FBI agent who would provide reliable informant information that Fatico was a made member of the Gambino family. Judge Weinstein ordered the government not to call a witness, concluding that this was a new allegation that was material to sentencing under the then special offender law, and that therefore such hearsay testimony would violate Fatico's confrontation and due process rights. The government sought mandamus in the Second Circuit, and as has often been the case, it won, at least initially. At the sentencing hearing on remand, the government had heard the judge. It called not one, but 10 witnesses. Judge Weinstein found that it had proved by clear, unequivocal, and convincing evidence, the necessary standard here, that the defendant was indeed a member of the Gambino family. On this basis, he explained, he sentenced the defendant significantly more severely than he otherwise would have. On the defendant's appeal, the government requested the Second Circuit to reject both the burden of proof standard the judge had used and also, quote, the entire concept of a sentencing hearing. The Court of Appeals addressed these matters in a footnote. It did not approve or disapprove of the standard of proof, and it did not require sentencing hearings for important disputed facts. It did, however, allow that, quote, we certainly would not hold it an abuse of discretion for a district judge to hold such a hearing. And so Fatico hearings were not instituted by the Court of Appeals, which never said they were necessary. They were not instituted through the criminal rules, nor by Congress or the Supreme Court. They were developed and instituted by Judge Weinstein. They became the practice throughout the Second Circuit and many courts beyond, and it's a testament to the judge's vision and persistence that the evidentiary hearings required by the Sentencing Reform Act of 1984 are called, at least in these parts, Fatico hearings. Now let me give but a glimpse of Judge Weinstein's sentencing jurisprudence in the years since the sentencing guidelines went into effect. It's not surprising that the creator of the Fatico hearing was initially well-disposed to the guidelines as a way to bring reason and some measure of process to sentencing. At the same time, he warned, as they were just going into effect, to apply the rules of the new system blindly amounts to injustice. No matter how efficient it would be, we may not delegate the sentencing decision entirely to the computer. As the radical nature of the guidelines became clear by the early 1990s, Judge Weinstein soured on them. His discontent coalesced into 4 main criticisms. First, because they were so rigid, they had perverted the sensible idea of reducing disparity into, quote, an unnecessarily cruel Procrustean bed. Second, while seeking to reduce inter-judge sentencing disparity, what they had actually reduced was inter-judge sentencing discussion, at least among the judges in the Eastern District of New York. Third, the new regime required judges to look at the bad aspects of the defendant, while neither probation officers nor defense counsel had incentive to be aggressive in seeking out the good. Fourth and foremost, the guidelines failed to treat each defendant as a unique human being. In a 1992 article entitled "A Trial Judge's Second Impression of the Federal Sentencing Guidelines," Judge Weinstein noted, "It would be historically and morally inappropriate to equate sentencing under the guidelines with deliberate and atrocious war crimes and genocide." But then in the next sentence, he quoted Hannah Arendt's work on the Holocaust and expressed his worry that under the guidelines, quote, "We judges will cease to aspire to the highest traditions of humanity and personal responsibility that ought to characterize our office." Judge Weinstein has never ceased to aspire to the highest traditions of his office. Acting within what he understands to be the limits of the law, which for this judge essentially are appellate cases directly on point and mandates from the Second Circuit to him, he has sought to find ways, where warranted, to accord mercy under the law. Early on, he became a judicial Houdini in freeing himself from various guidelines mandates. Thus, he read the Sentencing Reform Act to allow departures in areas that the Commission hadn't considered. He departed on the basis of physical illness, being a single parent, reduced mental capacity, insufficient evidence that the drug courier defendant knew the drug in the balloons he'd swallowed was heroin, and many more. In several cases, he deferred sentencing for a year in order to give the defendant an opportunity for rehabilitation. I get a special kick out of a case where the Second Circuit had earlier reversed his order granting bail. At sentencing, Judge Weinstein granted a departure because of, among other factors, the defendant's long pretrial incarceration under onerous conditions. So there, Second Circuit. Judge Weinstein actually got away with all the decisions I've mentioned. But perhaps that's because the government, for one reason or another, didn't appeal them. When it did appeal, he was less successful. The Second Circuit rejected, for instance, his fascinating and possibly persuasive argument in 1994 that a close reading of the Sentencing Reform Act revealed that the guidelines were not, in fact, mandatory. In another case where the Court of Appeals insisted that he apply a 6th-level increase due to relevant conduct, the judge asked, regarding the sentence he was required to impose, "Under the blindfold, does justice weep?" I note that's the title of Jeff's chapter about the judge's sentencing jurisprudence. As these decisions suggest, and as we've heard all evening, Judge Weinstein is proactive. In 2003, Congress enacted the Feeney Amendment, which required the Court of Appeals to review de novo any departure from the sentencing guidelines. The judge responded by publishing a memorandum in Federal Rules decision, which he called in re sentencing. There he announced that henceforth all of his sentencing hearings would be videotaped, quote, in order to assist the Court of Appeals judges in their new onerous task. And he went on, the appellate judges can observe the actual people they are sentencing. Not surprisingly, since Booker came down in 2005, Judge Weinstein has exercised discretion. And all those cases I mentioned, I think, would be recognized by the Second Circuit appropriate in the post-Booker era. For instance, he's refused to apply sentencing enhancements where there's no proof of mens rea, critical to the criminal law, he points out. And in an opinion spanning more than 100 pages, he decried, even as he applied, mandatory minimums for minor participants in drug crimes. As I noted earlier, he has also taken on the difficult and sensitive area of sentencing in child pornography cases. In the 2008 Polizzi case, he had to sentence a pizza shop owner convicted of possessing this material, where the guideline range was 13 to 15 years. In a later law review article, the judge referred to this defendant as, quote, a middle-aged, otherwise blameless, peaceful citizen and family man who viewed the child pornography from a locked room in his detached garage, in a locked room. Judge Weinstein varied the sentence from the guideline range of 13 years down to the statutory minimum of 5 years. Although the Polizzi case, like many, traveled several times between Cadman Plaza and Pearl Street, the Second Circuit ultimately allowed the sentence to stand, while rejecting Judge Weinstein's grant of a new trial and his argument that juries should be informed of applicable mandatory prison terms. In a child pornography case decided just a few months ago, the judge found that applying that 5-year statutory minimum would violate that defendant's rights under the Eighth Amendment's ban on cruel and unusual punishment. And this was no idle speculation. The judge wrote a 400-page opinion explaining the historical, doctrinal, and factual basis for his judgment. That 400-page opinion and all the others like it are, I think, crucial to understanding this judge. Critics and fans alike have sometimes made the mistake of thinking that, as Judge Cote put it, Judge Weinstein wears rose-colored glasses, or that he's soft on crime, or that he's just got this big heart that's out there with no boundary. It is true that Judge Weinstein is humane and empathetic, and that he has great social insight and compassion. He brings these qualities to bear in his judging. But he also brings to bear piercing intelligence that untangles complexity, and integrity that rebukes deception. He comprehends the whole of the law and never fails to explain his reasoning under the law. I would say of Jack Weinstein what he has recalled about great judges in the past. In a new article entitled "The Roles of a Federal District Court Judge," he writes, "A candid statement of the reasoning supporting the trial court's decision is always required. Mendacity in twisting the facts, evidence, history, or legal background to arrive at a conclusion is not acceptable." He then quotes Learned Hand's description of another New York judge. Quote, "Cardozo never disguised the difficulties, as lazy judges do, who win the game by sweeping all the chessmen off the table." Judge Weinstein has always acknowledged all the chessmen, all the laws that bind him and the litigants who come before him. But Judge Weinstein does play chess very well.
Judge, will you join us?
Well, I wish I could believe some of this. Dear friends, Professor Coffey refers to this evening as my canonization as a certified saint of the judiciary. I hope it takes place without a devil's advocate, and that it ends pre rather than post decease. For litigants, federal trial judges are, I believe, the human face of the law. We deal with particular cases and particular individuals. And as Carl Llewellyn told us in my first week at Columbia, we need to get a sense of the unique situation before us. So we are necessarily dealing, in each case, with the psychology of clients and lawyers, with sociology, with technology, with economics, and with politics. All in a legal context, all in trying to resolve the dispute before us, all while trying to do more good than harm. The judge's prayer, the let me this day do less harm than good. Before I respond to my fellow saints' overgenerous remarks, I'd like to touch on some fond memories of this great temple of justice in which these proceedings are taking place. It's been my exemplar of the majesty and power of the law to improve society. When I was law clerk to Judge Stanley Fuld, his chambers was those next door, formerly occupied by Cardoza. And I was constantly in the magnificent library of this building. And when I began my private practice a few blocks away, this is where I wrote my briefs. This is where I did the volunteer research for the NAC Legal Defense Fund. And when the library closed, I was sometimes ensconced in the Algonquin Hotel across the street, looking out at these 30 columns, Greek columns, for the psychic support that they give us. But it was the people, more than the structures, that instilled in so many of us youngsters the urge to practice in the grand tradition. The committee system here was a magnificent portal for neophytes like myself without any experience or familial background in the law. Judge Sylvia Single-Lease's committee, she was then a family court judge, was trying to improve that court. And she put me to work gathering drug statutes and cases, and that ultimately led to my chairmanship of the North Brothers Island Hospital for Young Addicts. And their cold turkey withdrawal is still before me when I sentence each day in court. And the Criminal Courts Committee had distinguished judges and practitioners who did not hesitate to express to me and other youngsters their wry view of colleagues over dinner. The Committee on State Legislation put me into monthly meetings with the most impressive practicing lawyers, just a young lawyer plucked out from Bensonhurst, where the Mafia had its center and where I went to school. And later, I acted as reporter after Harry Tweed, who was involved in some of that committee work, asked me to devise a plan for revising New York civil practice. And here we held the meetings for years under Jack Dykeman, and ultimately that led to the New York CPLR. So I owe much of anything useful that I've done in this to this great institution and the paragons that I met here. But now to the subject of the trial judge's role. It's set out very precisely in Rule 1 of the Federal Rules of Civil Procedure. Quote, secure the just, speedy, and inexpensive determination of every action and proceeding. And remember, though, unquote, remember, those rules were based on the 1914 equity rules. And what that means, and the genesis of those equity rules, and the genesis of equity, going back to the Middle Ages, which we studied at Columbia in our development of legal institutions, and which are the basis of anything I've done to mess up mass torts, is that the judges have the broadest discretion to develop procedures to meet modern society's needs. That's what equity did, and that was what the development was, and it carries through to the rules we apply every day. Rule 102 of the Federal Rules of Evidence, which I participated in drafting, I mean these words, quote, shall be construed to secure fairness in administration, elimination of unjustified expense, delay, and promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. And in the beginning of the criminal rules, it's even more succinct. Those rules must be, quote, interpreted to provide for the just determination of every criminal proceeding. Those are our guideposts. The detailed individual rules, the cases, whether of the Supreme Court or of anybody else, is mere commentary, so far as a district judge is involved. Those are the rules that we play by. And litigants look to us for justice. We have enormous flexible procedural powers to see that justice on the merits is done. For example, in a case which might turn on the facts today, since they've now tightened up pleadings to a point that perverts, in my opinion, the 1947 rules, I almost invariably convert the pleading motions to summary judgment, giving them a short period for discovery so I can get to the facts, find out what the controversy is about, and if it's got nothing to it, dispose of it. But if it has, go forward to trial. Now, in interpreting substantive law, we're more restricted. But the fact is, curiously, and it's always been curious to me, Dee, that every day we meet new substantive issues that we've never seen raised in exactly the same way before. So we constantly have to fill in the substantive lacunae in ways that don't distort the ever-changing, beautiful tapestry of the law, but that makes sense in the situation at hand. So, as Article 3 judges, we necessarily have, in deciding the cases before us, because our cases funnel up through the Intermediate Appeals Court and the Supreme Court, the same interpretive obligation and power in the immediate case in interpreting the law and the Constitution as any other Article 3 judge, including justices of the Supreme Court. We cannot do our work without exercising that power and understanding that we do have it. Now, in Erie matters, that is, state substantive law matters, we're more restrictive because of comity. Nevertheless, as far as lay people are concerned, this is one court system. They don't distinguish between state and federal courts. It's one judicial system, and we need to act with that in mind. For example, if I have a case involving where there are parallel federal or state cases, it's my practice, and I think it should be the practice generally, going both ways, of calling up the state or other federal judges and say, look, we've got essentially the same case going, let's get together and decide it. Sit together, decide the case together, so we can develop a single settlement or disposition, whether it's mass or an individual series of cases. Now, as to the Mark Twain and other school discrimination cases and the Agent Orange case and others, it was the equity procedures, the special masters, on-scene investigations by myself that I used. And in doing so, I looked back on what I learned the first year at Columbia from Julius Goebel and development of legal institutions and from the professors on equity. This is what a judge had to do, because you have to get a clear sense of the situation in order to be able to dispose of a litigation in a fair way and in a pragmatic way. Now, by contrast, and you did mention Zyprexa. In the Zyprexa case, we settled 30,000 cases when the MDL sent me the entire litigation, although there were some state cases still out there. We settled over 30,000 of the cases through special masters, matrices, and plaintiffs who were excellent lawyers, plaintiffs' lawyers, and defense lawyers. The most difficult part of that case was getting 50 different states and the federal government and the various attorney generals to agree on liens and holdbacks, and without doing that through massive national telephone conferences, it would have been impossible. And what I did want the quasi-class action concept for was to control the ethical problems which were out there in all of those individual cases, and to control fees, and to make sure that the clients got some of the benefits of the transactional efficiency that comes with mass torts, and to see that the discovery that we were doing in the federal courts was available to every court in the country, so that we didn't have a lot of reworking of the same matters. So it was a kind of a fast shuffle idea, but essentially it's sound. Mass litigations are different. You don't have the same relationship between the attorney and the client. You don't have the same fiduciary feeling where you're dealing with thousands of cases. You've got to have some judicial control in those cases in order to handle them properly. One thing that seriously disturbs me, and has disturbed me about Zyprexa, is a failure on my part. I never got to see any of the clients. I never got to see any of these 30,000 people who claimed injuries. These were cases, not individuals. It was not satisfactory. The individuals, except for a few who had trouble with their attorneys, after all, many of them were psychotic or had deep psychiatric problems. That's why they were using these drugs. Those individuals never really spoke to me, except in a few cases of summary judgment. We have to, it seems to me, in these mass cases, develop using the electronic social networking and other techniques for allowing all of these litigants to listen in, to know what's going on, to work with each other, and to participate in the litigation. That creates problems. It's much easier to settle a case where your litigants don't participate. When they participate and they start interfering, it's going to get more difficult. But it does seem to me we have to deal with that problem of getting people to take some control over their lives, and it has to be, it seems to me, it can be through a good deal more broadcasting and opening up of these litigations. The one area of cases where that has been done, I think with great success, is in connection with the 9/11 cases, where there has been an attempt to go out and speak to each in litigation in groups. Ken Feinberg and Judge Alvin Hellestein and why am I blocking the judge that wonderful judge who just been assigned a terrible job of doing the rest of the 9/11 cases? Sheila Birnbaum, have done that fairly successfully. And some of the litigants, attorneys, have begun and have done that with some success. In the DES cases, Sybil Scheinwald was brilliant in bringing together these daughters to work together and to talk together and to understand their problems. And they came before me and I listened, and I began to understand too what was available. Mel Weiss, who unfortunately, brilliant lawyer, had some problems with himself with the law, actually hired the professor at Harvard, now at NYU, Weinstein, Korn, and Miller, Arthur Miller. To go out and talk with these people. Essential in these cases. Now, how are we going to handle that? It seems to me to be raised a series of interesting problems. And it is possible, it seems to me, with new technology to do it. We haven't gone as far as we could in civil cases. Many people are not well represented. There's much more to do. The reason I like the class action is because it does level the playing field and gives a small person a chance to aggregate his strengths with the group at large. In the criminal law, we've largely provided for adequate representation. But the substantive law on sentencing and much of the protections in the federal courts are not fully effective. The Fourth Amendment is under serious attack, and there are other problems. If I were being tried as a criminal, I would prefer to be tried in the state court, New York state courts, which I think have more protections. So I agree with what Professor Coffey has written about the barriers that have been placed on class actions. The Walmart case and other cases have made it very difficult. But they are not going to prevent us from dealing with these mass cases, either in class actions or in related ways of avoiding, circumventing the barriers. So, if I can live for another 90 years, I can tell you, you can double your casebook, because that's the field I want to work. So thank you very much.
I guess we have time for 2 or 3 questions, so if there are any. Yes.
I can't hear you. Speak up.
You mentioned, without mentioning the names of decisions, but I think you were referring to pleading standards now, 2 mean equal, and
I find it difficult to pronounce the word. I can't follow the case.
But, and I can say, as a lawyer recently, not to your honor, the case of the district, that in my lifetime, that's a switch. And I think you hit upon it, which is the issue of if you have a fair ground in your statement, you have enough preliminary facts, but you need discovery to prove it, which is ultimate. What those decisions are doing are, in effect, putting it to you almost as if you need a wiretap, you need film, you need something so much more concrete. It's almost like the end of the story at the beginning. And I share with you that feeling that it's really an attack upon justice.
Well, it's beginning to close the door that the 1937 rules opened wide and that were widely opened in the post-World War II opinions. And if there is anything out there, you don't want to go to unnecessary expense. But if you use a summary judgment motion preliminarily and you bring in the parties and you have a colloquy with them about what there is out there, what bothers them, you can decide in many of these cases that either it goes forward or shouldn't go forward. There are some cases, obviously, statute of limitations, res judicata, which can be disposed of without summary judgment. But it seems to me that that rule on summary judgment, which has been used to bar cases by overuse, can be used to open up the door rather than close it.
If there are other questions, we have a mic over here. Do you want to just come to the mic?
I didn't.
Mandatory dispute resolution. Are you in favor of mandatory mediation?
No, I'm not. For one, I'm in favor of settlements and mediation, court annexed, and anything that can get the parties together without a lot of unnecessary expense, but not mandatory, because people have a right to the justice system that they paid for and that underlies all of the settlements that we have and all of litigation. Unless you have an operating, viable jury system and open, transparent court system where you can go to opinions and you can debate with and discuss among higher and lower courts, you don't have the structure that lies behind a good deal of settlement and a good deal of mediation. So mandatory doesn't strike me as useful.
Yes, you want to use the mic?
Do you remember how you settled Lady Orange? You kept us there all night, and we would have done anything because it was like 3 a.m. That's the one rule that way.
It was not cruel and unusual punishment. You deserved it, and you will recall that at the critical moment, I sent out for an order of prune Danish, which helped immeasurably in getting you in the right mood.
Any other questions? Yes, go ahead.
Judge, everyone knows now the Medicare fund is going broke. Everybody knows that the tobacco industry created a plague of disease which fell into the public had to take care of these sick people. Is there a way through that money can be recovered to the Medicare fund from the mass tort, which has already been established, I think, collaterally now in Washington?
I tried it through third-party payer actions in the tobacco cases, and it wasn't successful. Since I'm not running for president, I can't say any more about the problem.
There was, yes.
Judge, I'm also a student at Columbia, I'm a current student. What was in your time at Columbia, what was your favorite course or favorite activity?
Your favorite course when you were at Columbia. This comes from a current Columbia student.
I so respected that wonderful faculty that to pick out any one of those beautiful courses and therefore denigrate to some extent the other great professors would be inappropriate. You'll have to decide that for yourself.
Well then, there's a reception across the hall that you are all invited to. I'm even told there may be a book on the judge that's purchasable outside. And so please enjoy the reception.
Many